You have big plans for the weekend?
I'm going to Mizzou. That counts.
Really?
Yeah, my sister goes there.
I'm going to write a masterpiece to test my corporate tax class. What this means I'm going to take the final that I gave me in advanced tax and water it down some, because you're the advanced class, so I can handle that. But if you remember, the final from last semester in advanced tax, do you remember?
Yes.
It included the kitchen sink, so it's like, but I do have to water it down some. Question number 1, Katie. We want to acquire the entire business of Trin Corporation. Which of the following methods of business combination will best satisfy their objective without requiring the approval of the shareholders of either corporation? So Katie, a merger, would that require, so the question is, Katie, I'm trying to avoid a stockholder vote. Would I have to have one in a merger? So that's not the answer. Taylor, the sale of all the assets outside the regular course of business. And it seems like to me that, Taylor, if I sell all the assets outside the regular course of business, that's an extraordinary event that probably needs shareholder approval, so that's not the answer. Katie, and an acquisition of all the shares of Trent through a compulsory share exchange, does that require shareholder approval?
Yes.
And then D, a cash tender offer whereby Acorn basically goes on the market and acquires at least 90% of Trend shares. That would, in a sense, Katie, doesn't require shareholder approval because they have to agree to sell the stock, but not a shareholder vote.
Yes.
So, Katie, the answer is D, as in dog. Taylor, you agree?
Yes.
So, Kelsey, I can hit this little green thing? Oh, I learned something. And I remembered it last time. Question number 2. No, question number 2. Question number 2. Linda, under the revised Model Business Corporation Act, which of the following actions by a corporation would entitle a shareholder to dissent from the action and obtain payment of the fair market? So in other words, when can you as a shareholder force the corporation to buy your stock? So when can you do that? And under an amendment to the Articles of Incorporation that materially and adversely affects your rights, can you ask them to buy out your stock? Consummation of a plan of share exchange in which corporation is a party as the corporation shares will be acquired. If the stockholder is entitled to vote on the plan, can you force? So you disagree. The majority said do this, but you're in the minority and you say no. Can you force them to buy out your stock?
Yes.
Yes. So therefore, the answer to 1 is yes. Answer 2, yes. Therefore, and the answer to the question is C. Linda, you agree. C is in charge. Question number 3. David, which of the following would be grounds for the judicial dissolution of a corporation on the petition of a shareholder? Refusal of the board of directors to declare a dividend. David, are you owed a dividend? So that's no. B, waste of corporate assets. Maybe. C, lost operations of the corporation for 3 years. Are you guaranteed that you will make money? And in fact, is it common that particularly new ventures lose money for the early years? So that's no. Or D, so far A is wrong, C is wrong. D, failure by the corporation to file its federal income tax returns. That would piss me off. But I think, David, the answer is B or D. You agree?
Yes.
But I'm thinking, David, that somebody else is going to be more upset about the tax issue, namely the Internal Revenue Service. Therefore, I think, Bijou, the answer is B. B is in boy. David, you agree?
Yes.
Wow. Good job. Question number 4. Kayla, under the revised Model Business Corporation Act, following what type of corporate acquisition, bless you, does the acquiring corporation automatically become liable for all obligations of the acquired corporation? Kayla, I apologize, this is too easy. The answer is D, a merger. AJ, you agree? The M&Ms, Matt and Megan, under the revised Model Business Corporation Act, which of the following conditions is necessary for a corporation to achieve a successful voluntary dissolution? Successful application to the Secretary of State in which the corporation holds its primary place of business. Megan, let me make you the stockholder. Do you want to vote in this? Do you want to have some, so you're in a corporation, let's say with Matt, and the corporation is deciding to liquidate. Do you want to have, do you want somebody to ask your opinion?
Yeah.
And I see nothing about shareholders in A, so I don't think that's the right answer. Matt, a recommendation dissolution by the board of directors approved by majority, and Megan, you want to vote. Or C, approval by the board of directors of an amendment to the certificate of incorporation. Here, Megan, C has the same problem as A, since there's no vote of the shareholders, simply the board. Now, if you're upset with the board, you can vote the board out, but if they liquidate in the meantime, so in D, unanimous approval of the board of directors and a 2/3 vote of all shareholders entitled to vote. So it seems like, Matt, the answer is either B or D. In B, we have a simple majority and of both the board and the shareholders. In D, we have unanimous approval by the board and a supermajority by the shareholders. What do you think the answer is?
I believe it's B.
B as in boy?
Yes.
Megan, you agree? So now, Selene, what do I do now? So Alex, tell me what to do. Why am I in trouble today? Because I'm so proud of myself. Close that.
Actually, I will say she should. 'Cause
And then go to slideshow at the top.
Let's go to what slideshow?
You clicked on the wrong tab before.
Yeah,
Slideshow. Go to
yeah.
the tab that says slideshow at the top. At the top.
Yeah.
Oh, there.
And then click from again.
Oh, so what did I do wrong?
You clicked on the wrong tab at the beginning.
Whoa, man.
Okay, Alex, I'm kind of at a loss as to what to call this topic that we're doing today. Banker calls it other federal regulation. Your textbook puts it in a chapter on employment law, which I did not include in your version of the book, and I call it just odds and ends. So take your kind of stuff we need to talk about that doesn't fit anywhere else. Introduction. Davis-Bacon Act provides a prevailing that you have to pay employees prevailing wage. Walsh Healthy Act is the rule for minimum wages. Federal Labor Standards Act, extension of wage and hour regulation of workers in interstate commerce. And Sydney, you were my star student in legal environment like 5 years ago. What's the significance, Sydney, of the last two words, interstate commerce? Because if it were not interstate commerce, Congress would have no authority to do this. Delaney, you remember that, don't you? Sydney says, I guess. Child labor prohibits oppressive child labor practices. Under 14, only allowed to work in certain types of jobs. Good news is one of the types of jobs, Katie, that a child under 14 can work in is on a family farm. So you can put your 5-year-old to work out in the field. And notice, Angela, she says that with enthusiasm. I'm like, whoa. Overtime provisions and exemptions. Under the Federal Labor Standards Act, employees who work over 40 hours a week are entitled to 1.5 times per hourly wage for those hours worked above the 40 hours. You know, in France, it's anything over 30 hours. Overtime provisions and exemptions. Exemptions, certain employees, executives, professionals are exempt from the overtime requirements. Is this bad for accountants? Taylor, why?
I guess if they're considered as professionals, they work a lot, so they wouldn't get paid for overtime.
And therefore, as a professional, you can work your 60 hours a week and not get paid overtime. Certainly, most of the CPA firms pay overtime to interns, but not to professional staff, because I guess as an intern, you're not a professional yet. Sydney, you agree that's bad for us?
Yes.
Coverage and application. The Federal Marital Leave Act requires employers with over 50 employees to provide up to 12 weeks unpaid leave to employees who need to care for a spouse, child, or parent suffering serious medical condition, passed back in the 1990s. Employee must be restored to position upon return to work unless it's a key employee. So, Sydney, you take time off to care for an elderly parent, and they have to give you up to 12 weeks off, and with not necessarily with pay, and you're able to return to your job unless you're a key employee. As an accountant working for a CPA firm, so you were a manager, you can come back and keep your job as a manager. So, Sydney, what would be a key position to where you would not get your old job back after 12 weeks? Maybe if you were the chief financial officer. Okay. Violations, damages, job reinstatement, and promotion. So Sydney will put you in the position you would have been in had you not taken the 12 weeks off. In France, I don't know why I'm in France today, you can take 12 weeks off with pay. And we wonder why their economy is suffering. Did I say that? Because I'm spending too much time with Andrew and beginning to sound like a Republican. Occupational Safety and Health Act. Fundamental federal law aimed towards safety in the workplace. Enforcement is by OSHA. State workers' compensation laws establish procedures for compensating workers injured on the job. Instead of suing for injuries, a worker is automatically compensated. Therefore, there's strict liability. When we say strict liability, Candace, what does that mean? So you're injured on the job. What if you're injured on a job, Candace, because of your own negligence? Can you still receive workers' compensation?
Yeah.
And the answer is yes. All you have to prove is an injury on the job when you say the employer has strict liability, even if it were your fault. But, so I think that's a good thing, but it bars plaintiff from suing, but also bars the defendant from any applicable defenses. Now, how does this work? So you get workers' compensation, you're injured on the job, who pays you, Candace? The state does. But where does the state get the money from? A tax on the employer, and that is based on their history. So therefore, if they have a long history of people collecting workers' comp, then their rates go up. And that sort of makes sense, Michael, because certain jobs are inherently, think coal mines, are inherently more dangerous than other jobs. So in a sense, you're injured on the job, and probably you're injured on the job because Sydney took 12 weeks off to care for her elderly parents, and so you're a shorter person. So it's really Sydney's fault. So in a sense, Kelsey, the employer has an economic concern here. In a sense, they don't. They don't have an economic concern here since it's not paying the money. But it does have an economic concern here because the more people put in for workers' comp, the higher their rate. So therefore, they have an interest in you not doing this. But notice the Act prevents any defenses. So they could not say, well, it's Candace's fault or it's Sydney's fault because it's strict liability. So arguably, Kayla, workers' compensation is good for the employees, and then arguably, Linda, it's bad for the employees. How is it good, Kayla?
And it saves them the trouble of litigation.
Saves them the trouble of litigation. Also, they're guaranteed that they are, in fact, on the job. Of course, Brandon, there may be some debate about what on the job means, but other than that, you're guaranteed a payment. You will be compensated for your injury. But then, Linda, arguably that's bad for employees because
It could also disincentivize them to go back to work as well.
now you're sounding like a Republican. Think legal issues and not behavioral issues. Kobe?
That's what I was gonna say.
Let's suppose, Kobe, let's suppose we're in West Virginia, and that's coal mining country, and everybody, and we're in a town of 30,000 people, and everybody in the town either works in the coal mines or they have a relative who works in the coal mines. And let's suppose that we have a mining company that has a terrible safety record, and they've been cited by OSHA 25 times in the last 2 years for safety violations, and there's a cave-in at the mine and somebody's injured. Would you rather take Linda workers' comp, or would you rather sue the people, I'm cleaning up my language for Angela, or would you rather sue them and get punitive damages in the millions of dollars? Kobe? So therefore, workers' compensation guarantees that you'll be compensated for your injury. It also protects the employer from having, and think, Kobe, who would be a jury of their peers? Other people who are pissed off at the coal mines. Okay. Is workers' compensation subject to tax? Michael, tell me what you're being compensated for, and then Katie, tell me yes or no. So Michael, you're being compensated for your injury. Now Katie, generally, damages awarded for physical injury are not subject to tax. There is a specific exclusion. So workers' compensation is or is not taxable?
It's not.
It's not. And that makes sense, Michael, because you're being compensated for your injury. Now, what about unemployment compensation? Talini, so you're unemployed. I'm sorry. What are you being compensated for?
Not having a job.
No, for your lost wages. So you were making $1,000 a week, and now suddenly you're making nothing, so you get unemployment compensation, you make $200 a week. So since you're being compensated by your job, and if you were still working, would you be taxed on your wages? Therefore, would unemployment compensation, Megan, be taxable?
Yeah.
Yes. Because if you had still been working, the thing that you're being compensated for is taxable, while with workers' comp, the thing that you're being compensated for is not taxable. Okay. Social Security, a portion of income, whether paycheck or self-employed, goes to FICA, Federal Insurance Contribution Act. Generally, I wouldn't worry about the tax rates because I seldom see those tested, or what the threshold amount is. I think it's 113 now. The purpose of this slide, Linda, is to point out the difference in Medicare and Medicaid. Medicare is a federal program that is funded out of Medicare taxes, and it's for the elderly. Medicaid is funded by the state, and it's for the poor. So could you be collecting both? Yeah, if you're old and poor. So you will never be collecting Medicaid because you will never be poor. And by the time you turn 65, well, we'll know. We'll see what happens. Social Security are paid to the worker, the spouse of the worker. Megan, what about a divorced spouse? Take the case, David, where you are married and you, David, are a stay-at-home husband. And you take care of the family and so forth, while your wife goes out and works. So that means that, David, you don't pay into Social Security because you have no job, because you're a stay-at-home husband. And then, after 30 years of marriage, she leaves you and goes with a younger man. It's too bad that you can't get a picture of David's face because it's pain. So Megan, would the divorced spouse who's never worked be entitled to Social Security through her ex-husband, his or her ex-husband?
As long as she's not remarried?
Yes. Well, but let's think about that. Let's suppose, David, that you remarry. Let's suppose that you remarry, but the person that you remarried was a stay-at-home wife. Then could you both collect? Yes. You could collect through your former wife, and she could collect through her former husband. And that makes sense, and in fact, arguably, Kelsey made more sense 40 years ago when we had more stay-at-home spouses. Social Security benefits are also paid to disabled worker and to children of deceased or disabled workers until the age of 18. Private pension plans, ERISA, was first passed in the 1970s. It was called the Accountants for Employment Act because it led to the complications that you see in Accounting 303 with pensions. Thank ERISA for that. Has certain vesting requirements because what would happen, Linda, is somebody would work for 20 years and they would have a pension plan that did not vest until you were there for 20 years and you were laid off after 19 years and 11 months. And that was fairly common practice where enough, I don't know if it was fairly common, but it was enough of a practice that it led to the passage, was one of the things that led to the passage of ERISA. So you got to have certain investing requirements and certain requirements to invest in funds. And that's necessary, David, because it's one thing to promise you a private pension plan, but I need to put aside money to provide for it. Which is why most companies don't have pension plans anymore. Unemployment insurance. FUTA created a state-run system. Federal law creates a state-run system provides unemployment compensation for those losing jobs, designed to compensate workers who loses her job. COBRA provides a federal right to continued health insurance. Worker has, so Cindy, Cindy, you're on unpaid leave. You lost your job, Candace, right? So you've lost your job. No, you were injured on the job. You lost your job. Kobe, you lost your job.
Sure.
So you're on unpaid leave. You are just were injured on the job and you have lost your job. And the issue comes up, Kobe. Arguably, one of the problems with the healthcare field in the medicine in the U.S. is that health insurance is tied to employment. You lose your job, you lose your health insurance. And what COBRA did is it gave you 60 days to go out on the market and to purchase insurance. And that might be important if you had a pre-existing conditions. Now, the Affordable Care Act, under current law, they can't discriminate against you for a pre-existing. They can't turn you down for a pre-existing condition. But prior to that, what COBRA did is COBRA guaranteed you that the right to buy insurance, no matter how bad your health is, if you bought it within 60 days of losing your job, and you can keep the insurance for up to 18 months or until you find a new job. However, this coverage can be very, very expensive because it could be that on your prior job, the insurance premiums were paid by the employer. Here, the premiums would be paid by you. So it could be a very expensive proposition. But at least you have the right to buy health insurance. Affordable Care Act, otherwise known as Obamacare, employees with 50 employees are required to offer health insurance benefits. Businesses may be eligible for tax credits for providing this. Currently, the ACA is subject to challenge in court, and basically there have been 3 challenges to the Affordable Care Act. Congress considered this a couple of years ago, and there's a case pending in the court now. I would expect a decision soon. Here are the challenges. Linda and Kobe. The first challenge to the ACA was that Congress, with the individual mandate, and Linda, the individual mandate requires that you either have to buy insurance or be subject to a penalty. And that penalty is currently, what, $75?
$95 or 10%
$95 or 10% of,
household income.
it's cheaper to pay the penalty.
Yeah.
Particularly COVID, so you're 25 years old, COVID, and you're in good health, and you know that when, God forbid, you're diagnosed with heart disease, that the insurance companies have to insure you. So what's your motive to buy insurance now? I don't think there is a motive. But you could be subject to penalty. And the argument that was made against the ACA, Linda, was that Congress has the authority to regulate commerce. But Linda, this is not the regulation of commerce, this was the creation of commerce. In fact, Justice Scalia, a very famous question during the ACA case in 2013, asked the question, if the government can force me to buy insurance because it's good for me, can the government force me to eat broccoli? That's a very interesting question, and here's what happened. Linda and Candace, I predicted, when I was teaching legal environment, I predicted what the court would do. I also predicted what the court would do in a same-sex marriage case. In a same-sex marriage case, I predicted exactly how they would rule. I predicted it would be a 5-4 decision, and I predicted that Kennedy would write the decision. So I was and I also predicted they would not do it on equal protection grounds, but would do it on grounds of states' rights. And I was spot on. Well, the Affordable Care Act, the argument was that this is a violation of the Commerce Clause because it's not the regulation of commerce, it's the creation of commerce. The government's backup argument, Linda, was that even if the Congress cannot do it under authority of the Commerce Clause, they could do it under the taxing authority. And in class, Candace, I ridiculed that argument, and I said, a penalty is not a tax. Give me a dictionary, I'll show you. So I predicted, Candace, that ACA would be upheld under the Commerce Clause. And I was so good with same-sex marriage. What happened, Linda, is they ruled they could not do it under the Commerce Clause, but they could still do it because the penalty is a tax. Congress has the right to tax, therefore the individual mandate is constitutional. To which I say, Candace, they need a dictionary. Okay, that was the first challenge, and that was a constitutional challenge. And if you think about it, Linda, we're going to talk about 3 challenges. A constitutional challenge is by far the most serious. Because if it's a constitutional problem, the proponents are going to have to change the Constitution. And that's very, very hard to do. Second challenge, Kelsey, was that according to the Constitution, tax legislation, and remember, after all, the ACA, the Supreme Court said this was a tax bill. To which I say, Candace, they need a dictionary. But Kelsey, the Constitution says that tax bills have to originate in the House, not the Senate. Now, Kelsey, you're a student of American history. Why is that true? The Revolution was about taxation without representation. The Revolution was about Parliament imposing taxes on the American colonies, although the colonists had no representation in Parliament. And it was thought, Taylor, that since the House is elected by the people every 2 years, and the Senate originally was chosen by state legislatures and now by popular vote every 6 years, then therefore, Kelsey, the body which is most responsive to the people is the House. And the argument from the challengers was that bill originated in the Senate, and therefore it was unconstitutional. DC Circuit says that's not a problem because what they found is they found a tiny piece of legislation that originated in the House, and then the Senate added a 2,400-page amendment to it. And therefore, the DC Circuit says that's not a problem. Supreme Court decided not to hear the case. Now, Kelsey, if the Supreme Court does not hear the case, that means that the lower court stands. So 2 challenges have failed. The third challenge, which is the one that's pending now, it provides the tax credit to buy insurance, the bill provides, for those who buy insurance on the state exchange. Now, but it's optional for states to set up exchanges. Missouri and 36 other states did not, so therefore, Sydney, a Missouri resident, would have to go to the federal exchange to buy insurance. But, well, wait a minute. Sydney, and the way the system works is you go to the federal exchange, you estimate your income, and then they compute how much of a tax credit that you would get to buy insurance. Now, you could get that by going to the federal, a Missouri resident can get that by going to the federal exchange, but the bill says that you'll get the tax credit if you to buy insurance for those who buy insurance on state exchanges. And you bought it through the federal exchange. Tellini, who lives in California, well, they did set up a state exchange, bought it through the state exchange. Therefore, that means, Sydney, that if you take this literally, then she would get the credit from California, but you would not. But then, Sydney, it's clear to me what Congress intended to do. Congress intended, first of all, Congress thought that all 50 states would set up exchanges. So the intention, Sydney, was that you both should get the credit, and therefore, 3 circuits have considered. The question says, yes, go by what Congress meant. One circuit, the 8th Circuit, said that yes, go by what Congress said. So now, Sydney, is this a matter of constitutional law, or is this a matter of statutory construction? Which means that in a normal time, this could be easily fixed by Congress simply changing the law. But Sydney, are these normal times? Would a Republican-controlled Congress fix Obama's number 1 achievement, what he calls his number 1 achievement? Now, it seems like to me that if they go and say, if they agree, Candace, and say that we go by what they said and not by what they meant, and also, Sydney, Congress passes what are called technical correction acts, where they basically go in and clean up the language. And what the tax court has routinely said, Linda, is that from the period of time when a bill was passed to it was corrected, we'll go by what they meant. So there's strong precedent to go by what they meant. But if they go with what it was said, doesn't that raise Sydney an equal protection problem? Kobe, that means that citizens in one state will get a credit from the government to buy health insurance, and citizens in another state do not. And to make this even more problematic, it's generally, Linda, the states that chose not to do it are generally controlled by Republican governors and Republican legislatures, which means that citizens in democratically controlled states get the credit and others don't. How can that? Surely that's not what they meant. Now, Candace, I predicted that when this came up at the circuit level, I said, no way is this going to be a problem. This is silly. But one circuit said, disagreed. And Sydney, once the circuit split, does the big guys have to take the case? Yeah, because this is a big issue. And Alex, once 3 circuits say one thing, the other circuit says the other, Now, what's the court gonna do? And Candace, I learned my mistake. There's also a Supreme Court decision, as you know, about same-sex marriage. And I'm gonna predict what they're gonna do in that case. I'm not gonna predict what they're gonna do in this case, because it's like, because, Linda, this case is tied up not only with law, but with politics. So, to summarize this, and the other thing is, Kelsey, if they say that yes, go with what Congress meant, then that solves the problem. If they say yes, go what Congress said, then you also have a constitutional challenge on the equal protection grounds, and then the whole thing might fall. So, to summarize, Linda, 3 challenges to ACS. One based on the Congress exceeded authority with the individual mandate, that failed. One was the bill should originate in the House, that failed because we had a one-line act passed by the House, and the Senate simply amended it with 2,400 pages. And that happens all the time. And the third, Candace, the more serious problem is, do you treat people in one state differently from another state? And that is a serious problem. And so to answer that question, you need to come back, check the Supreme Court docket in June. So that's odds and ends. Next week we'll start with SEC, securities regulation. Judge, I have a receipt for you. This is in Chinese to the committee. This is from Chin's Palace. That's the one across from the fire station.
That's the one. You know?
And then you can put in this receipt. 445.